we have anyone in the jail that's ready? I'm not sure I can hear anything from the jail court. Mr. White, can you say something?
Yes, sir.
Oh, there you go. Okay, I guess y'all were just really quiet over there. All right, Mr. White, let's see who we got. Flip by. All right, this is Talia Powell, CR 21306. And I guess my paperwork went to the jail rather than being here. So you've got to remind me what we're doing, Mr. White.
I'll defer to Mr. Woodwhack.
You're gonna have to remind me who we're even talking about.
All right, the state's going to withdraw their motion to revoke. Ms. Powell is going to be extended 1 year. She's going to have her time, which I believe is 26 days at this point, eaten up, and she had to become current on her fines, which she's done.
That Judge, we're gonna do that.
Okay, and has this been approved by probation, or is probation been consulted? Are they in agreement?
Judge, I believe they are.
Yes, sir.
All right, thank you, Ms. Burns. All right, and so do you have the paperwork there with you, Mr. White, on the motion to withdraw, amend, extend, and jail time as a condition?
Yes, sir. And I've provided it to Ms. Clark.
Okay. All right, Ms. Powell, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Ms. Powell, you've heard what Mr. White and Mr. Woodwhite have said regarding your case. Is that true?
Yes, sir.
And is that the agreement that you want to make with the state with regarding this motion to revoke?
Yes, sir.
And Ms. Powell, has anyone forced you, threatened you, made you feel like you had to make this agreement wherein your probation will be extended and you'll lose any credit for any back time for any time that you spend in jail on this case?
No, sir.
Okay. All right, then the court will grant the state's motion to withdraw. The court will approve the amendment to the conditions of community supervision for her, Ms. Powell's back time to be considered as a condition of community supervision. And the court will extend her community supervision for the period stated in the amendment.
Yes, sir.
All right, thank you, Mr. Powell.
Your Honor, that's all I have. May I be excused?
Yes, thank you, Mr. White. And I appreciate it again, Mr. White. Let me say just publicly, thank you for coming and assisting Judge Winters in the County Court of Law with that issue earlier. Really do appreciate it.
It's no problem, Your Honor, anytime.
Thank you, sir. We have anyone else that's ready?
Mr. Smith will be ready in about 30 seconds.
Mr. Who?
Smith. Hey, Bobby.
All right, court call CR 22-271, State versus Bobby Lynn Evans. Mr. Evans, if you'll raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you got to speak up a little louder for me.
Yes, sir.
All right, you can put your hand down. Mr. Evans, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me about that?
I took psych medication and TDC for around 3 years,
And then, when I was released, I took it for another 2 years before I stopped taking it. It was for anxiety and depression.
Okay. Are you currently on that medication today?
No, sir.
Are you under a doctor's care for anxiety or depression?
No, sir.
Do you feel like today you have a rational understanding about what's going on in court?
Yes, sir.
Feel like you understood everything that's happened in your case, everything you discussed with Mr. Schmidt?
Yes, sir.
And are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
And do you feel like you've had enough time to talk to him about your case and that you've had all your legal questions answered?
Yes, sir.
In this paperwork where you signed, you're telling me that that is your true and correct signature and you've only signed once you understood what you were signing.
Yes, sir.
Mr. Schmidt, do you believe Mr. Evans to be competent today?
I do, Judge.
And have you explained to him his rights and also the advantages and disadvantages of a deferred adjudication plea?
I've explained that, yes.
Do you believe he understands that?
Yes.
And you also believe that he is entering into this plea intentionally, knowingly, and voluntarily?
Yes.
All right, Mr. Evans, you are charged by indictment with a third-degree felony offense of failure to comply with sex offender duty to register for life annually. The court would admonish you that a third-degree felony in the state of Texas carries a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000. I see that the range, or that the plea agreement in this case is that you would plead guilty to that crime in exchange for the state's recommendation that the court defer a finding of guilt, place you on community supervision for 3 years, and fine you $1,000 plus court costs and reimbursement fees. Is that your understanding of the plea agreement, Mr. Evans?
Yes, sir.
Mr. Evans, you understand that if I approve this agreement, if you violate any of the terms of your community supervision, the court could conduct a hearing. And if the court finds that you violated, the court could do a number of things, including adjudicating you, convicting you of this offense, revoking you from community supervision, and sentencing you anywhere between that range of 2 years to 10 years in prison. You understand that?
Yes, sir.
Understanding all that, you still wish to go forward?
Yes, sir.
All right, Mr. Evans, then how do you plead to failure to comply with sex offender duty to register?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this crime today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No, Judge.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we'd rest and close.
Anything further from the defense?
Nothing further, Judge.
All right, court will review the evidence. All right, court has reviewed the evidence. I do find sufficient evidence to convict Mr. Evans of this offense. The court will follow the plea agreement reached between the state and the defense. Court hereby defers a finding of guilt, places Mr. Evans on 3 years community supervision, orders him to pay $1,000 fine, $290 court costs, $585 reimbursement fees. Mr. Evans, you're hereby remanded to the custody of the Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. After you are fingerprinted with the bailiff, then the probation officers will give you information about the next step.
Sir.
Anyone else ready? Mr. Knoll, you ready?
We are good.
All right, Mr. Crane. Right, is cause for CR 2156. Robert Cecil Crane Jr. Crane, if you'll raise your right hand, sir, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Your name is Robert Cecil Crane Jr., correct?
Sir.
And Mr. Crane, you are a United States citizen who reads, writes, and speaks English, is that correct?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me about that?
Split personality, bipolar and schizophrenia and PTSD.
Are you currently on medication or under doctor's care for that?
Yes, sir. I am.
Okay, and you feel like you have a rational understanding of the court proceedings going on here today?
Yes, sir.
All right, and in this case, you're represented by your attorney, Mr. Knoll. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to talk with Mr. Knoll about your case and that you've had all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork, Mr. Crane, that you signed today that you do not understand?
No, sir.
Mr. Knoll, do you believe Mr. Crane to be competent today?
Judge, I do. Actually, we visited earlier in the week and I think it was Tuesday, Wednesday, whatever day. He was here and then we visited again before lunch today. I believe that he does understand what's going on today.
And you've explained to him his rights with regards to this plea agreement?
I do, Your Honor.
Do you believe that he's entering into this plea agreement intentionally, knowingly, and voluntarily?
I believe that he is.
Okay. All right, Mr. Crane, you are charged by indictment with a second-degree felony offense of sexual assault of a child, which carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. I see that there's a plea agreement in this case wherein you would plead guilty to that crime. The state would recommend your sentence be assessed today by the court at 10 years confinement. Okay, with a $2,500 fine, and your case would run consecutively with your Wood County cause numbers. In addition, you would have court costs and reimbursement fees, and you would receive 706 days credit toward your sentence for the time that you've been in jail. Is that your understanding of the plea agreement?
Yes, sir.
That's what you want the court to approve?
Yes, sir.
All right, then, Mr. Crane, then how do you plead to sexual assault of a child?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. Knoll, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence in State's Exhibit 1 is admitted. The court takes judicial notice of the defendant's judicial confession. Any further from the state?
Yes, Your Honor. There is a victim impact statement submitted for this case that I believe Ms. Taberham was going to provide to you. We would ask that you review that now if you haven't already. Take judicial notice. Additionally, there is a protective order on this case. I emailed Mr. Knoll yesterday and I haven't heard back on whether that will be agreed or whether we will need a subsequent hearing after the conclusion of the plea.
Judge, actually, on the protective order, we were given a copy of that, I don't know, half hour ago or so. We've reviewed that. We can agree with that. We won't need a further hearing on that.
Okay, thank you, Mr. Knoll. All right, the court will review the evidence at this time, and also the court will review and take judicial notice of the victim impact statement. This will be just a moment. All right, the court has reviewed the evidence. The court has reviewed the victim impact statement, and the court will follow the plea agreement reached between the state and the defendants. Court hereby convicts Robert Cecil Crane Jr. of sexual assault on a child, a second-degree felony, assesses punishment in accordance with the plea agreement at 10 years confinement. The Texas Department of Criminal Justice orders a $2,500 fine, $290 court cost, and $120 reimbursement fees. And the court awards Mr. Crane 706 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Crane, you're hereby remanded to the custody of the Banzai County Sheriff so he can carry out the terms and conditions of this sentence. I'll have you step over with Deputy Everett and you'll be fingerprinted. Ms. Heisel, I will sign the victim impact statement tracking form, and I'll leave that here with the clerks to pick up.
Thank you, Your Honor. We'll come get it.
You know, is that all you have today? Or do you have, no, you have Joshua Holloway, is that correct?
That's correct, Judge.
All right, this is cause number CR 2225, State versus Joshua Dwayne Holloway. Set for arraignment today, is that correct, Mr. Knoll?
That's my understanding, Judge. He's actually.
I think prison.
No, but before that. Says he actually was brought from a TDC unit here, has some time there and out of Hunt County where he was held for a little while. I think this case can be worked out. His name is spelled correctly, understands what he's charged with. For the purposes of arraignment, we'd enter a plea of not guilty, but I think this will be resolved by way of plea. We could have whatever the court's next setting is, maybe we can work that out that quick.
Would February 21st, that'll be the very next docket setting, it's week after next. Be the Tuesday week after next.
Maybe the one after that. I'd be a little quick.
March 7th or March 9th.
March 9th.
Okay. All right, the court will find that Mr. Holloway has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record and will set this matter for pretrial hearing, which could become a plea. March 9th at March 9th at 1:30.
Thank you, Judge.
Thank you, Mr. Knoll. Mr. Schmidt, who are you ready on?
Richard Shivers.
I guess, is this an add-on? Because I don't know. You got this on your
We sent them from Tuesday, Judge. It didn't make it to the list, I guess, but we reset him on Tuesday.
Okay. Can you give me his call number?
CR 22-00364.
And what do we set for? What do we reset for from Tuesday?
Hearing a plea. So
Okay, can you go ahead and give me the terms of the plea?
I can, Judge. Mr. Shivers is going to plead to injury to the elderly attempted. A state jail felony prosecuted under 1244A. 140 days in jail, credit for 140 days, $500 fine, $290 court costs, and $585 reimbursement.
Any 1245s or weapon forfeitures or anything?
No, sir.
Okay. All right, Mr. Shivers, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear, your other hand? Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Mr. Shivers, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Today, I'm bipolar.
Okay, are you on any type of medication or under treatment for bipolar?
I'm trying to get back on the medicine when I get back out. I gotta
Okay.
get my doctor again.
Okay. Do you feel like you're suffering from that today to the point that you don't understand what's going on in this case?
Yes, I understand.
Okay. And you understand that Mr. Schmidt is your attorney. Are you pleased with Mr. Schmidt as your attorney?
Sir,
You feel like you've had enough time to talk with him about your case and that you've had all your legal questions answered?
yes, sir.
Anything about the paperwork that you've read over and signed today that you do not understand?
Oh, I understand.
Mr. Schmidt, do you believe Mr. Shivers is competent today to enter into this agreement?
I do, Judge.
And you've explained to him his rights and you believe that he understands those and he's entering his plea intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Shivers, and was Mr. Shivers originally charged by indictment with injury to an elderly state jail or F3? I don't have it.
Judge.
F3, okay. Mr. Shivers, you were originally indicted with injury to an elderly individual, a third-degree felony offense. However, the plea agreement today, as Mr. Schmidt has read to the court, would be an attempted injury to elderly, which is a state jail felony offense, which would carry a range of punishment under section 1244A to not more than 365 days in jail and a fine of not more than $4,000. You heard Mr. Schmidt read the plea agreement today, is that correct?
Yes, sir.
And that's what you're asking the court to approve.
Yes, sir.
All right, Mr. Shivers, then how do you plead to attempted injury of an elderly individual under
Yeah.
section 1244A?
Got you.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we'd rest and close. Let me check on, we are in victim compliance. I do not believe that we have received a victim impact statement in this charge. We are in compliance. We have not received a response to our request for a victim impact statement.
Okay, anything further from the defense?
No, Judge, it's only that I have spoken with the alleged victim, who is the spouse of Mr. Shivers, and she had asked me how to go about filing an affidavit of non-prosecution. And I don't know that she had the transportation to make it to the DA's office, but ultimately, just so the court's aware, she would not have sent back the impact statement under the circumstances.
All right, thank you, Mr. Schmidt. All right, Mr. Woodwhite, can you give me the evidence to support the plea?
Yes, Your Honor. On April 12th of last year, the sheriff's office called out for a disturbance. They speak with the victim, who is 68 years old. She states the defendant attacked her with a mop. Victim states the defendant was upset and they were arguing all day. And he wanted to mop the floor of her travel trailer because a dog made a mess, but she wanted him to go back to his motorhome, which is on the same property, and they would deal with it later. She told him not to use Pine Sol and asked him to stop cleaning the mess until he became irate and began to attack her with the mop. Sheriff then speaks with the defendant. He states that the victim assaulted him with the mop and that he's not sure why. Both parties have injuries. The sheriff's office believes most of them to be unrelated, but photographs all of the injuries.
Thank you, Mr. Woodwhite. Anything to add, Mr. Schmidt?
Judge, I would just add that it's our perspective that this was a mutual combat situation and a mutual domestic disturbance and argument that got out of hand. But ultimately, we would not object to the state's assertion of the facts.
All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Shivers of this offense. Court hereby convicts Richard Shivers of attempted injury to elderly A state jail felony prosecuted under section 1244A, the court assesses sentence under 1244A at 140 days confinement in the county jail with credit for 140 days time served. The court orders him to pay a $500 fine, $290 court cost, and $585 reimbursement fees. Mr. Shivers, when you get out of jail, you need to make arrangements to repay the county the orders, the financial obligations that you've been ordered today, your fines, your court costs, your reimbursement fees. If you can't pay all of those at once, you'll need to make a payment plan with the court collection officer, and your failure to come and make that plan and then adhere to that plan will result in the court issuing a warrant for your arrest. Do you understand?
Yes, sir.
All right. All right, you're hereby remanded to the custody of the sheriff so you can carry out the terms and conditions of the sentence. Step over with the deputy to be fingerprinted.
That's all I have, Judge.
Thank you, Mr. Schmidt. Do you have anyone else that's ready?
Yes, Judge.
And Mr. Manning, I was going to tell you that a few of your clients have appeared that were supposed to be here this morning. Mr. Cotton, Ms. Turner,
Yes, Judge.
and well, I think that those are the only two that were yours.
Yes, Judge. I've been in communication with Ms. Turner. I had her check in with Ms. Tatum, and I'll be over there to do her plea just shortly.
That's fine. I'm having Mr. Cotton UA today as well, so we're doing that right now.
Yes, Judge.
Who are you ready on at the jail?
We can start off with Mr. Ozuna.
Richard Ozuna, CR 22-385 and CR 22-282, set for pretrial. Go ahead, Mr. Manning.
Judge, as you know, we've been saying this for at least 4 months now to get, I think, what's some serious discovery that could be very enlightening to the situation at hand. It may be the only video of what actually happened. It was seized off of a DVR that was belonging to the homeowner where Mr. Ozuna was staying, and that is in possession of the state. It was part of the evidence that was seized and cataloged. As of today, I have yet to receive that discovery as I've requested it in writing multiple times, as well as had meetings with law enforcement and the DA's office attempting to get that. I filed a motion to compel discovery that was filed on Monday, requesting that discovery be turned over under 3914, as well as additional discovery that may or may not exist, that may or may not be a part of the case file. At this point, I'm kind of unsure what we should have, because there seems to be a lot of information that, given the level of investigation that occurred with this case, should be turned over that hasn't been turned over. And so we're asking for the court to compel that discovery, compel the state to produce that discovery, and if not, to exclude that discovery from future proceedings.
State.
Judge, this is Ms. Curry's case. I was not aware of Mr. Manning's motion filed on Monday. Because of that, I really can't comment on the status other than we'll address that with Mr. Manning, get on the same page. and see if for some reason we don't have something that is available, we will produce that. But like I said, I've been unable to personally review that, so I really couldn't comment on specifics.
And Judge, at this time, I'm asking not only to receive that discovery in whatever form, but also to inspect it. So I like opportunity to inspect the gun or guns that were allegedly seized, the DVR, any physical evidence. I would request opportunity for myself to see that and review it and inspect it personally.
I can't imagine the state would have any objection to that, Your Honor.
Okay. All right, court will grant the defense's motion and compel the state to produce the video footage of the digital video recorder, which was seized in this case, and produce that to the defendant. The court will also grant the defense motion to inspect the physical evidence, including the DVR and any firearms, and order the state to make arrangements to assist Mr. Manning in discharging that order.
And Judge, will there be a deadline for that to be provided?
Let's see, you filed your motion on Monday, correct?
I believe it was Monday. Yes, Judge.
Have you brought this to the state's attention before that?
Judge, my first initial contact with Ms. Curry in the state was in October, when I in writing requested the DVR.
In state, you don't know if the DVR has been forensically searched and processed, do you?
Judge, the last information that Ms. Curry gave me was that the Texas Rangers had the DVR, but they had not forensically examined that, and that was at the end of last year, beginning of this year.
And Judge, I don't have any update in the case since the end of last year.
All right, the court will order that the state produce the DVR discovery no later than March 9th. And we'll come back for an additional pretrial on that date. Who do you want next?
Judge, if we can do Mr. Clarence Smith.
Mr. Smith, you'll come forward, please. CR 22-285, 286, 287, 288, 289, 290, 291, 292. I believe that was set for pretrial on all cases.
That's correct, Judge. At this time, we have no contested pretrial and request to be set on docket call announcement.
All right, and is the standard 30 days sufficient, Mr. Manning, or do you need more time?
Judge, I believe that will be sufficient.
Okay, court sets Mr. Smith on all cases for docket call on March 9th at 1:30. Who do you want next, Mr. Manning?
Mr. Johnny Cooper.
Johnny Jude Cooper, CR 2326 and CR 2239. Show that we're set for arraignment in each case.
Yes, Judge. This is an older case. I have not received a discovery, or at least when I last checked, I had not received discovery. If we could possibly view the indictments, so we can confirm that his name is spelled correctly and then he understands the charges that are against him.
Sure, give me just one moment. I'll pull that up.
Judge, his name is spelled correctly. He understands the charge against him. He, at this time, pleads not guilty and requests to be set for pretrial.
What about this one too?
I'm sorry, Judge.
What about this one too? I was just showing 326. Look at the indictment here in 239. He has two cases, I believe.
Yes, Judge. Judge, right now we're seeing just, I think, the 3261. Judge, his name is spelled correctly. He understands the charge against him and pleads not guilty and requests to be set on pretrial on that as well.
All right, the court will enter Mr. Cooper's plea of not guilty into the record for each cause, finds that he has waived the formal requirements of arraignment. We'll set each case for pretrial hearing. Do you need more time than that March 9th?
No, Judge, that'll work.
All right, court sets each case for March 9th. 1:30 if Mr. Cooper's in jail, 9 a.m. if he's on bail. Who do you like next, Mr. Mean?
Judge, if we can call Mr. Michael Murphy.
Michael David Murphy, CR 22-153 pretrial.
Yes, Judge. Judge, I had an opportunity to sit down with Mr. Murphy and go over his discovery. There were a couple things that at the discussion he's wanting me to look at and investigate, and so I request some additional time to investigate that as well as negotiate with the state.
Any objection from the state?
Judge, is this a request for additional pretrial or are we moving to docket call?
Additional pretrial.
I don't believe state has an objection to that, Your Honor.
All right, court will grant Mr. Murphy an additional pretrial hearing on March 9th at 9 a.m. Or I'm sorry, at 1:30 p.m.
Judge, if we can call Jesus Gutierrez.
Jesus Gutierrez, CR 2050.
Okay, Judge, Mr. Gutierrez, our last court date was orally ordered to go to safety, and we were told that the paperwork would follow. The last I checked, the paperwork had made its way somewhere between the clerk's office and probation. And so I'm unsure exactly why Mr. Gutierrez is here at this point.
I guess I'm equally unaware. Which one is it?
Judge, and it appears that they have amended him on February 2nd for safety, so I assume he's just waiting for a bed. I guess he was. They said January 17th. And so it looks like we're just waiting for a bed for him. I guess there was another setting out there that didn't get changed.
Okay, so Mr. Gutierrez has already been, his case, his motion to revoke has been resolved. and
Yes,
we're
Judge.
Just waiting for him to be shipped to safety.
That's correct.
Okay, all right, I will remove it from my docket.
Judge, ready on Mitchell Ragland.
CR 21-185, State versus Mitchell Wade Ragland. Is this a plea today, Mr. Manning?
Yes, Judge.
All right, can you tell me the terms of the plea?
Yes, he is pleading true to state's motion to revoke. And upon plea of true, the agreement is that we reach with that punishment is assessed at 6 years, TDC, and the balance of financial obligations.
Just one moment.
Oh, and I'm sorry, I didn't read the term. The balance of his financials is $2,500. The court cost is $209, reimbursement $85, and he has a total of 240 days confinement on this charge.
240.
That's correct, Judge.
Are you able to see that, Mr. Manning?
Yes, Judge, and that's the same motion that we discussed prior to this hearing.
Okay. All right, this is cause number CR 21-185. Mr. Ragland, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can lower your hand. Mr. Ragland, you appeared before the court on January 6th of 2022. You pled guilty to the second-degree felony offense of aggravated assault causes serious bodily injury. The court heard the evidence, followed a plea agreement in your case at that time. Court assessed your punishment at 10 years confinement in prison, but suspended that sentence and placed you on 5 years community supervision and ordered you to pay a $2,500 fine. It was during your period of community supervision that the state filed its motion to revoke community supervision. And then the state filed an amended motion to revoke, and then the state filed that second amended motion to revoke. The one before the court is this one filed August 4th, 2022. Do you feel like you've had enough time to discuss this motion with your attorney, Mr. Manning?
Yes.
You feel like you've had enough time to talk with him about this to the point you've had all of your legal questions answered?
Yes, sir.
And you see in this motion, the state has alleged in 9 counts of ways they are alleging to the court that you have violated the terms and conditions of your community supervision. You understand that, correct? I'm sorry, I couldn't. Did somebody say something?
That's my understanding.
Okay, I'm sorry. All right, and Mr. Manning, do you believe that your client is competent to enter into this agreement today?
I do, Judge.
And does he intend to play true to all 9 counts?
Judge, I believe there've been some discussion about abandoning the Oklahoma ones. I don't know if that makes much of a material difference one way or the other. I defer to the state as to what their position is.
Sorry, Judge, couldn't find my unmute button. Judge, state had discussed that with Mr. Manning back when the Oklahoma cases were pending. However, it's my understanding that that has been resolved in total. I believe that the judgment does reflect every violation listed in the state's motion. I wouldn't be opposed to abandoning those. But we would need to amend the judgment to remove condition G and condition C.
If that's y'all's agreement, that's your agreement. That's fine with me.
Judge, let me speak to my client just for a moment. Judge, he would like to go forward with what was the original agreement of having those off.
Okay,
And Judge, I will get an amended judgment sent over to the jail with those reflections.
And Judge, what I'll do is I'll also strike through the state's motion counts 6 and 9, which is G and C of conditions. But beyond that, he is pleading true to the remainder.
okay. All right, so Mr. Ragland, then you understand the plea agreement that Mr. Manning read to the court, that you're going to plead true to counts 1, 2, 3, 4, 5, 7, and 8.
Yes, sir.
All right, and in exchange, the state's recommending that your community supervision be revoked and you be sentenced to 6 years confinement in the Texas Department of Criminal Justice, with you being ordered to pay the balance of the financial obligations previously owed, and you would receive 240 days credit towards your sentence for the time that you spend in jail in this case. Is that your understanding of the agreement?
Yes.
All right, so Mr. Ragland, then at this time, how do you plead to counts 1, 2, 3, 4, 5, 7, and 8? Are those counts true or not true?
True.
And are you telling me that those allegations are true because in fact they are true? You're not just saying that to get a certain plea agreement?
No, they're true.
All right, then the court will accept the defendant's plea of true. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of truth?
No objection, Judge.
All right, then that's admitted as state's evidence. The court will take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Defense rests so closed, Judge.
All right, then, based on the evidence presented to the court finds that Mr. Mitchell Wade Ragland was placed on community supervision by this court, has violated the terms and conditions of his community supervision. Court will follow the plea agreement in this case. The court, having found the defendant's violations to be true, hereby revokes his community supervision and assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice. Institutional Division orders him to pay the balance of his financial obligations and orders 240 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Ragland, once you get out of TDC, if there's still money owed, you'll need to report to the courthouse and meet with a court collection officer to make arrangements to pay that so that a warrant doesn't issue for your arrest, okay?
Understood.
All right, Mr. Ragland, if you'll step over with the deputy to be fingerprinted, we'll be adjourned in this case.
Judge, I have one more plea with Mr. Skinner. I have yet to be able to go over the paper with him if I can have just a couple minutes. Additionally, I believe I have, I have an announcement for the court on Mr. Boylan. I was informed as I came to jail today that he refused to come to court today, that he would like to re-urge his motion to have new counsel appointed or if not, to have me fired. I assume, I haven't spoken to him, assume to be, proceed pro se. I don't have any further updates as to his position. I don't believe it's changed much as a Terrell State. And I believe that my personal observation is that his mental health continues to decline while he's here in the Van County Jail.
And Ms. Abraham is here in court with me. Remind me if either one of you know, is he currently on voluntary medication for his mental health, or is he one that's not been deemed a harm to himself and is not on?
I don't believe he has been deemed a harm to himself. At least at last check. I could confirm with jail staff if you'd like.
But you said that you believe that he's deteriorating.
He's become more erratic in his communications. I know that one day recently when I was in court in Kaufman County, he placed quite a number of calls to our office repeatedly without ceasing.
Would you like for the court to have him evaluated now that he's already been found incompetent? Would you like the court to have him evaluated to see if one of the treating physicians from the Andrew Center believes that mental health medication intervention would improve and or at least keep him from deteriorating?
Judge, unfortunately, I feel like it's a physiological problem that is the root, the base of that. I'm not a doctor, as I mentioned earlier today, so I don't know if that would help, but I'm open to any suggestions at this point, as he is kind of just continuing to languish here in the jail.
Okay, I'll talk with Ms. Abraham and we'll come to a conclusion on that, and we'll keep both you and the state updated on if we're going to have him evaluated for that.
Yes, Judge.
So and so Mr. Boylan said that he didn't want to come forward today. Is that correct?
What was communicated to me by the day sergeant was that he refused to come to court today, and that he wished for my services to be terminated.
Ms. Heisel, you were going to say something?
Your Honor, I was just gonna tack on the end of Mr. Manning. My recollection is that the evaluation for competency reflected more, like Mr. Manning said, physiological than a diagnosis that would support that medication might be able to help. But obviously, state would have no objection if there is something available for him.
Okay. We'll reanalyze that situation for Mr. Boylan. All right, court's going to waive Mr. Boylan's presence here today on the finding that he has been deemed incompetent. The court is going to deny Mr. Boylan's request to have Mr. Manning removed as counsel at this time, and we don't have any further updates from Terrell State Hospital on his placement on the list either. So once we have that information, we'll share that with the defense and state as well. So let's set him out to April. And then if anything occurs between now and then, Mr. Manning, that we need to be aware of, I trust that you'll advise the court.
What date on April, Judge?
Let's do April 6th. Is there some cruise on April 6th?
Judge, that's 3 days before we leave, so I think I should be all right to appear for Mr. Boylan.
We can bump it later if you want.
Judge, you're right there before I'm out of Dodge, so.
All right, well, let's do April 6th, and then maybe that you'll definitely need more R&R that very next week.
I appreciate it, Judge. Like I said, beyond that, I have Ms. Heath, who I haven't seen brought forth. I believe the state was going to agree to a bond on Ms. Heath to resolve her current situation and put her back out on probation. I haven't seen any paperwork reflecting that at this point.
Judge, that's not I think I wouldn't disagree with Manning in principle. It is an MTA. The state would agree to a bond. The only allegations on the MTA are new charges from Mount Vernon. I believe the state's intention is to, at this point, allow the Mount Vernon case to move forward. Basically see what the prosecution happens there. So we would not be opposed to a bond, but I don't believe that that will necessarily resolve her business here. We would ask that we agree to a I don't remember if we spoke to about a specific amount, Mr. Manning, but if you'd like to make a request I think we can likely come to an agreement. If we could discuss that, Judge, probably not in open court. We can probably reach an agreement such that she can be released on our MTA. She can go handle her business there, and then that will likely instruct our resolution here.
And Judge, I haven't, since speaking to Mr. Woodwike about this case, I haven't had a chance to speak to Ms. Heath, but as soon as she comes in, I'll speak to her and communicate with Mr. Woodwike.
Yeah, give me just 1 second here. Let me pull up her MTA. What's her bail set at? 50 right now, it looks like.
I'm not sure, Judge.
Yeah, I think her current bail is 50,000. And that seems to be the sole count. Okay, yeah, let me know if y'all come to an agreement on something, I'll consider it.
Thank you, Your Honor.
Do we need to go ahead? Are we only set today on her for your motion, Mr. Manning?
No, Judge, that's set for state's motion to revoke. It's our first setting. I have spoken to her.
Is she there in the courtroom with you?
Not yet. I was told, informed by Deputy Everett that she's on her way. If
Okay, that's fine. We can wait till she gets in here that way. She's part of it. And Mr. Skinner is going to be a plea, correct?
That's correct, Your Honor.
Judge, has Miss Kayla Moore, has she been appointed counsel? Do you know the status on that case?
He has, yes, Mr. Manning.
Okay.
All right, I guess we'll stand in recess for a few moments and let Mr. Manning deal with his clients there, and then he'll need to come to the courthouse to deal with the morning docket people that just showed up. So we'll stand in recess for a few minutes. Mr. Manning, you ready? You ready, sir?
Yes, Judge, ready on Miss as well as Mr. Jones.
All right, Jerry Ann Heath, CR 22-313. This is on the motion to revoke.
Yes, Judge, motion to adjudicate, I believe. State agreed to a reduction of her bond to $15,000 PR bond. And I've explained to Ms. Heath that she is still on probation, that she is still ordered to do all the conditions of probation and responsibilities. And I've explained to her that she needs to take care of that as soon as she gets out.
All right, court will grant the reduction from a $50,000 surety bond to $15,000 personal bond on the motion to adjudicate. Court will set this for motion to adjudicate hearing. We'll set this for the contested docket on March 30th. And then we'll give the other counties some time, and state can decide what they want to do on whether they want to proceed on this count or not.
I would appreciate that, Judge.
So that'll be at 9 a.m. on March 30th. And Mr. Manning, are you getting me an order for that? Is there an order on file?
Judge, there is not an order, there's not been an order filed, but I will execute one when I get back to the office.
Okay.
Actually, Judge, if I may, I might do that before I head back over to the courthouse. I'll bring that in hand when I come to the courthouse.
Okay. All right, who else did you say you're ready on?
Judge, Mr. Dennis Jones, he was on the morning docket, but has actually been in custody this entire time.
All right, CR 21-328, 2021-540 and 541, State versus Dennis Ray Jones, set for pretrial. Go ahead, Mr. Manning.
Judge, I think we might be close to a negotiated settlement on a couple of these cases. I need to speak to the state. My understanding was that Mr. Jones had bonded out when he went to jail on last court date, but he is in fact here. So I need a couple minutes, or a couple days to speak to him. If we can do a shorter reset, I think we may have some idea of a resolution.
All right, court will place it on the contested docket for February 23rd at 1:30. You want to make an announcement on Kayla Moore? I think you were just appointed on that today, so motion to revoke. You might not be aware, Mr. Manning, are you?
Judge, I was not, now that you say that, Ms. Taberham mentioned I might have a new one today, but I did not realize that Ms. Moore had been appointed.
Is she there?
She is there. She is here. Judge.
Ms. Moore, come on up. This is cause number CR 18-442, State versus Kayla Jo Moore. Ms. Moore, the court has reviewed your request for court-appointed attorney, finds you to be indigent at this time, appoints the Honorable Jonathan Manning to represent you. Mr. Manning was just appointed today. He's not been given any information about your case. So the court's going to reset this motion to revoke hearing. We're going to set this on March 9th and give Mr. Manning a chance to get with the state and get more evidence about your case so that y'all can make a decision on how to resolve it. No, we still have Mr. Skinner, I believe. All right, Mr. Manning, is Mr. Skinner a plea today?
Yes, Judge.
All right, CR 18-507, CR 23-16, State versus Andrew Skinner. Mr. Skinner a plea today?
I'm sorry?
Is Mr. Skinner a plea today?
Yes, Judge.
All right, can you give me the terms of the plea?
State is proceeding under CR 18-507. The motion to revoke. Motion to adjudicate. The terms of that are going to be upon a plea of true. State's motion to adjudicate. Defendant's guilt will be adjudicated and community supervision will be revoked. Punishment assessed at 13 years TDCJ. Balance financial obligations. Additionally, Judge, I don't see in the paperwork here, but as part of our agreement, there's going to be a dismissal of a new case that was filed just recently. And so I'll make sure when I get to the courthouse that paperwork is executed as well, but state agreed to dismiss the new charge. That was.
And Your Honor, I was just gonna say, Your Honor, that's correct. I have the motion to dismiss. I'll print it and bring it to the courthouse when I come after docket to sign the rest of the paperwork. I didn't realize it wasn't in the plea packet until just now, but I have it prepared.
In the case you are referencing, is it this indicted CR 23-16?
Yes, Your Honor.
Okay. All right, Mr. Skinner, if you'll raise your right hand, I'm going to place you under oath. Mr. Skinner, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Make sure you speak up loudly and clearly for me. Mr. Skinner, you appear before the court. Can you see this motion to adjudicate I'm putting on the screen?
Yes, sir.
Okay, Mr. Skinner, it appears that you were before the court on March 21st of 2019. You pled guilty to the offense of assault of a family or household member by impeding breath or circulation, a second-degree felony. The court heard the evidence, found that there was enough evidence to convict you, but the court followed a plea agreement that day between you and the state. The court deferred a finding of guilt and placed you on community supervision for 5 years, ordered you to pay a $2,000 fine. It was during that period of community supervision that the state filed this motion to adjudicate and revoke on September 29th of 2022. Mr. Jonathan Manning has been appointed to represent you. Do you feel like you've had enough time to talk with Mr. Manning about this motion and have all your legal questions answered?
Yes.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, I don't.
Okay, you're going to have to speak up so my court reporter can hear you. She has to write down what you're saying, okay?
No, Your Honor.
Okay. Mr. Manning, do you believe Mr. Skinner to be competent to enter into this plea agreement today?
I do, Judge.
And you've explained to him his rights as they pertain to this state's motion to adjudicate?
I have, Judge.
And does he intend to plead true to all 6 counts alleged?
Judge, with the abandonment, I assume that would be, sorry, with the dismissal, I assume we would be abandoning count 1 and just pleading on the remainders. But I didn't specifically speak to Ms. Heisel about that.
And Judge, this, I didn't notify Miss Abney, but count 1 is the CR 23-16 case that we are dismissing today. So I will again send an updated judgment out to the jail, removing that count.
So the state's withdrawing count 1?
Yes, Your Honor.
All right, so Mr. Skinner, then you heard Mr. Manning announce the plea agreement is that you would be adjudicated and he's convicted of this offense from 2019, and this cause number CR 18507. You'd be convicted of assault of a family or household member. Your community supervision would be revoked. You would be sentenced to 13 years confinement in prison with the balance of your financial obligations. Is that your understanding of the plea agreement?
Yes, Your Honor.
All right, then, and Mr. Manning, how many days credit does Mr. Skinner have towards his sentence?
I show that he has 120 days, Judge.
120 days. Okay. All right, Mr. Skinner, then let me ask you, how do you plead to counts 2, 3, 4, 5, and 6 as contained in the state's motion? Is that true or not true?
True, Your Honor.
Are you telling me that those counts are true because in fact what's being alleged is true?
Yes, Your Honor.
All right, and you're not just saying that counts 2 through 6 are true, or 2 through 6 are true just because you want a certain plea agreement. Those things that they're alleging actually occurred. You didn't pay, you didn't do your community service, you didn't take your class, those things, correct?
Yes, Your Honor.
All right. Has anybody threatened, forced, or pressured you to plead true to any counts today?
No, Your Honor.
All right, court will accept the defendant's plea of true to those counts alleged which have not been abandoned. And Mr. Manning, any objection to the admission of the defendant's plea of true and waiver into evidence?
No objection, Judge.
All right, that's admitted in evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. With regard to cause number CR 23-16, which is going to be tendered as a motion to dismiss, there is an affidavit of non-prosecution on file for that charge, which is the reason that the state is submitting a dismissal.
Okay. Anything further from the defense, Mr. Manning?
Nothing from defense, Judge.
All right, based on the evidence presented to the court finds that Andrew Skinner was placed on community supervision by this court, and that during the period of his community supervision has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this case. The court does find those counts to be true. Court finds that the state has abandoned count 1, and on the basis of that finding, the court hereby revokes the community supervision of Andrew Skinner, assesses his sentence pursuant to the plea agreement at 13 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations, and awards him 120 days credit towards his sentence for the time that he has spent in jail on this cause. And the court will dismiss cause number CR 2316 on the motion of the state. Mr. Skinner, you hereby remanded to the custody of the sheriffs who can carry out the terms and conditions of the sentence. I'll have you step over with Deputy Everett to be fingerprinted. Mr. Manning, how long will it take you to do that order on Ms. Heath?
Judge, it should just take about 5 minutes.
Okay, I was gonna say I could try to knock that out for you if you wanted me to. Tell you what, let me do that, and it'll save time, and you come over here and you can visit with your clients.
Yes, Judge.
I'll work on that in the meantime.
Thank you, Judge.
You're welcome. If there's nothing further from the jail, then the jail can log off, and then I assume the prosecutors, you'll stay on Zoom for the remainder of this morning's docket that has appeared in the afternoon.
Yes, Your Honor.
Yeah, could I get who appeared?
Yes, let's see. It was Mr. Cotton, which was Ronnie Dwayne Cotton, CR 22-240, Mr. Manning's client. Also, Miss Brittany Deshaya Turner, CR 21-400, Mr. Manning's client, and then Noemi Esquivel, motion to revoke, no attorney.
Thank you, Judge.
Roll.
Okay.
I'm just getting to Everett.
Okay.
Yeah, that should be-
And if you don't get me.
Okay. See y'all back in. Yeah.
Hillary,
Yes, Judge.
I accidentally removed Tyler from Zoom rather than the jail. They were right
Oh.
under each other and I fat fingered it. So go tell Tyler to log back in. My apologies.
Well, Judge, I think I may discuss with him. I may just come over to the courthouse. I've got stuff to bring over and then he can just be released.
Okay, well, he'll owe you then.
Okay, thanks, Judge.
All right, thanks.
I'm curious to see what our jury pool percentages the Monday morning. Happens. That it won't be, I bet it won't be significantly impacted.
Well, they could be,
No,
set that would be quite different now.
yeah.
I don't think it will be as different as,
I don't care.
both Texas guys. All right, this is cause number CR 21286. You're Noemi Esquivel, is that correct? Am I saying that correct?
Yes,
Okay. All right, Miss Esquivel, you were set at 9 o'clock today. Where,
I wasn't aware of that talk.
and who's your bondsman? Is it still
Easy.
Easy Pickens? All right, I think he's the one that contacted the court and told us that you thought it was what, this afternoon?
I wasn't there.
All right, so you do have a motion to revoke that has been filed against you. Do you intend to hire an attorney to represent you?
Yes,
Do you know who you're gonna hire?
the same one from last time, I think,
Okay. All right, so if I give you a reset until March 9th, you believe that you can have him retained and in court with you on that date?
yes.
Okay. All right, court will set Ms. Esquivel for motion to revoke hearing on March 9th. Now, I think someone's already told you, but you're reminded that you're still on probation. Just because they filed a motion, doesn't mean you stop reporting, stop paying, stop doing those things, okay?
Yes.
All right, so go ahead and sign your notice of setting there and we'll give you a copy. See you back on March 9th.
It's a-
And are there any probation officers in here right now? You might want to check with the probation officers before you leave. They may want you to check in today. I don't know. The last time you've seen them, but you may want to check. Okay, all right, you're free to go.
Then they need that stage. I crossed it out and later they wanted. Fix the video, so. That's sort of.
Okay, I can remember which.
I mean,
we went with.
We can just mark it out. If it's gonna be a time served, you can just mark it out.
I also heard. I don't know, I'm sure, does that get 2 days or something?
You have that paperwork.
She's bringing it back.
All right, we'll go ahead and call Mr. Cotton.
Judge, if I may have, I haven't had an opportunity to not quite yet.
Okay.
I understand what the court has been, is that correct?
Correct.
Okay. May have someone to talk to him about what's going on.
Okay. All right, court calls, Mr. Cotton, come on up. CR 22-240, State versus Ronnie Dwayne Cotton, set for pretrial. Mr. Cotton was set at 9 AM. Court had his name called. He was not present. Court was issuing a judgment nisi alias capias. Then Mr. Cotton appeared this afternoon. So the court will withdraw the nisi and alias capias. Mr. Fanny, go ahead, set for pretrial.
Yes, Judge, I believe we're gonna have some contested issues, based on my conversation with Mr. Cotton. Unfortunately, because of some, kidney stone issues, he has been unable to, come to my office to review the discovery, but he has informed me via telephone, of some of the issues that he expects, for us to see on the video. And we're sure.
We have to do the initial on the specialist to give her.
Judge, if we could do a short reset, I think I could get an opportunity to go over the issues that Mr. Cotton has in the case and get something filed. If you want to just set it on a short set.
I don't mind setting until March. I mean,
Okay.
I'll give you the standard time if you need to get him in to file your motions. Court will set Mr. Cotton for pretrial hearing on March 9th. That will be at 9 AM if he is on bail, 1:30 if he's in jail. Mr. Manning, the court had Mr. Cotton tested, because he was late. The nature of the charge, and Mr. Cotton admitted to, according to, the pretrial release officer, Mr. Cotton admitted to use of marijuana, but also tested positive for methamphetamine.
Yes, Judge. I had an opportunity to speak to Mr. Cotton about that. First, my understanding was that prior to just a few minutes ago, he was not on condition of pretrial release, or not ordered on condition of pretrial release. Secondarily to that, I would like the results sent off to the lab to be tested, as he maintains that he was not positive for it.
Well, so the court's going to order Mr. Cotton to appear at the pretrial release department tomorrow at 10 a.m. to give Mr. Waddell an additional sample. And that's going to be tested and sent off to the lab, and we're going to take this issue up on March 9th.
Yes, Judge.
For my job. What we're gonna do is, I've reset you to March 9th, okay? You signed your pretrial release today, okay? You know better than using methamphetamine, whether you're on conditions of pretrial or not. I don't know if the conditions are enforceable today, but they will be enforceable from here on out. If you come back on March 9th, you have marijuana, meth, alcohol, anything, you're gonna go to jail immediately. You're gonna stay there till your case is resolved. Are we clear? All right? We'll see you back on March 9th at 9 a.m. and I would not be late. If you're gonna be late, don't think you're gonna show up in the afternoon. If you show up in the afternoon, you show up at the jail. It'll be an easier way to get you booked in. All right? You're free to go.
And we're ready to proceed.
All right, this is cause number CR 21-400, State versus Brittany DeShia Turner. Ms. Turner, if you'll raise your right hand, I'm gonna place you under oath. Ma'am, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may lower your hand. Your name is Brittany, is it DeShia or DeShia? Okay, so it's AI, so just A. All right, Ms. Turner, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with any type of mental condition?
I have ADHD.
Okay, well, are you on any kind of medication for ADHD? All right, and you don't feel like it's affecting your ability to understand what's going on in this case?
At times, there's been times that she's had difficulty understanding what's going on in this case, but as of today, she's.
And you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney? Do you feel like you've had enough time to talk with him about your case and that you've had all your legal questions answered? Is there anything about the paperwork that you've read over and signed today that you do not understand? All right, Mr. Manning, do you believe Ms. Turner to be competent today?
She has been.
And you believe that she understands her rights as they pertain to this case and the consequences of her plea?
She does.
And you believe that she's entering into this intentionally, knowingly, and voluntarily?
I do.
All right, Ms. Turner, you were originally charged by indictment with a state jail felony offense of abandoning or endangering a child. However, I see that the plea agreement in this case would result in the reduction of that charge to a Class A misdemeanor prosecuted under Section 1244B of the Texas Penal Code. The plea agreement being that upon a plea of guilt, the state would be asking the court to assess your punishment at 2 days confinement in the county jail, with you receiving credit for 2 days of time served, a $1,000 fine plus reimbursements and court costs. Is that your understanding of the plea agreement? And the range of punishment for a Class A misdemeanor is that your jail time could not exceed 365 days. So the court would find that this plea agreement would legally fit within the range of punishment. So understanding all of that, you still wish to go forward? Okay. All right, Ms. Turner, how do you plead to abandoning or endangering a child, a Class A misdemeanor under Section 1244B? Are you pleading guilty to that crime because you are guilty of committing that crime? Are you sure?
Judge, we talked about the difference between legal culpability and mitigation that she has provided to me and I provided to the state, which has led to this deal. What happened was no mission. So that's been the struggle. It was a lack of action is actually what led to the charge being filed with this.
So Ms. Turner, understanding that, you're telling me that you are legally responsible for committing this crime. And has anybody threatened you, forced you, or pressured you to plead guilty to this crime today? All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection to state's evidence and judge that presented earlier. Ms. Turner believes her time to be 23 days. Well, it's not particularly relevant. She did want the court to know she's been longer than 2 days. This still.
Judge's case dates back quite a bit, so I think it's probably likely that she was booked in under a different software that we just don't have the complete time for, but this is state's agreement to proceed under this.
All right. I'm not sure if I said it, but just for the record, court will accept the defendant's plea of guilt. There's no objection to the state's evidence. Is that correct? State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state,
No, Your Honor.
from the defense? All right, court's gonna review the evidence. All right, the court's reviewed the evidence and the court finds sufficient evidence to convict Ms. Turner of this offense. Court will follow the plea agreement in this case. Court hereby convicts Brittany DeShay Turner of abandoning or endangering a child, Class A misdemeanor under Section 1244B, assesses her punishment at 2 days confinement in the county jail, issues her 2 days credit for time served, orders her to pay a $1,000 fine, $270 court costs. Mr. Turner, you hereby remanded to the custody of the Manatee County Sheriff's to carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with Deputy Everett. And then you'll need to go upstairs to either pay off everything that you owe or meet with the court collections officer to set up a payment plan on the 3rd floor, okay? Deputy Everett. All right, I believe that concludes the court's docket for the day. Anything else that you're aware of? All right. All right, that will conclude in the court.